Welcome, everyone, and thanks for tuning in to Cherry Becker's latest technology podcast, where we are continuing a brief series on global tax matters for tech companies. Today, our discussion will be focused on research and development activities and the impact of Section 174 when conducting business either overseas or in multiple countries. You'll hear from a few members of Cherry Becker's Tax Credits and Incentives Advisory Practice, Marty Karamon, Vivian Kohrs, and Bryan Weems. I'll now hand it over to them.
Maggie, thank you so much. And everyone, thank you for joining the podcast today and listening. I'm proud to be the leader of our Tax Credits Incentives Advisory Group. We have a lot of members who've joined the team over the last few years. We're growing quite a bit. From the Big Four and other places, we are focused on everything from research and development analyses to cost segregation to a lot of analysis right now of some of the energy provisions under the Inflation Reduction Act. In addition to some state credits and incentives work that we're doing. Beyond that, even the firm focuses quite a bit on the new markets tax credit. So to the extent anyone has any questions after they listen to this podcast on R&D and 174 or anything else, please reach out to Cherry Becker. I am proud, as always, to work with and introduce two members of my team today. One, Vivian Kohrs, who is a director in our group, primarily focused on R&D, in addition to Bryan Weems, who is a senior manager focused on R&D as well. At the end of this, I'll give a little update on where we are with some with some pending legislation and what may happen with that. But I don't want to get into that too much because the law's a little bit in flux. I want to focus on the way the law exists today. And so that's what we're going to do today. So with that, we're going to kick it over to Bryan Weems. Bryan, how you doing?
Doing well. Thanks so much for having me, Marty. Really appreciate it. Again, this is such a broad scope, right? And maybe to start us off, it may be helpful to provide some brief background on the capitalization requirements surrounding 174, as well as touching on, well, what is 174? What are Section 174 costs that we have to evaluate? So even stepping back briefly to 2017, one of the budget balancer items from TCJA was the mandatory capitalization of Section 174 costs for companies beginning after December 31st, 2021. And so really what we have to look at, similar to R&D credits, right, is a geographic lens. So for work or development that's occurring domestically, that's actually capitalized across 5 years with a half-year convention. So year one, instead of being able to fully deduct your Section 174 costs, you're now only getting 10% of that. And for anything that is occurring overseas, boots on the ground, whether it's employees or contractors, that's actually amortized across a 15-year period. So again, with half-year convention, that gives you quite a bit of spread rather than being able to deduct that all in first year. So whenever we say Section 174 costs, what are we really getting at? And so, we live in a world of acronyms and definitions. So what we're looking at under Section 174 really relates to specified research or experimental expenditures, so SRE. And whenever we're talking about SRE, really it's quite a broad definition. It's all costs incident to development. And so a non-exhaustive list that I have here would be, labor costs for contractors, full-time or part-time employees that are either directly performing, supervising, or directly supporting SRE activities. It could be the cost of materials or supplies that are used or expended in the development process. Legal cost for filing or trying to obtain a patent, cost recovery allowances associated with any property or equipment that's used in the performance of SRE. So again, that's not an exhaustive list. It's quite broad. And so a great example I like to think of is if I'm a software engineer and I'm physically coming into the office, there's a portion of the rent or the facility costs that are allocated to me. There's a portion of electricity that's powering my laptop that's allocated to me. There's the fully burdened cost of my employment, including fringe benefits. So again, we have to look at all costs incident to development. And as I'm sure y'all could imagine, there's quite a bit that could go into that. And, with that, with these regulations and, with the notice 2023-63, which came out in September, there is, some lack of clarity on the regulations. And maybe Vivian, you could speak a bit more to that. that topic.
Absolutely. And I know when 2023-63 came out, we were so excited because it did provide finally some guidance from the IRS that we were waiting on for the longest time for the 22 tax filing year. That didn't come out until September of 2023, so I'm sure that was a mad dash for a lot of people. But even with that notice, there is still currently a lack of clarity within both the regulations and the notices that result in potential double capitalization, which I think is a big problem for the tech industry, especially for companies in the tech industry that have maybe multi-entities or maybe they have foreign entities. So double capitalization is when you have the same set of research and experimentation costs that need to be capitalized by both the payee and the payer of the R&D activities. So say, for example, you have your tech company, you have a US entity that pays your foreign entity in India or Ukraine to develop software on your behalf. And the US entity and the foreign sub both share that IP, and potentially both parties, because of that, will need to capitalize for 174. The foreign entity 174 essentially impacts the flow-through income from that foreign entity to the US. And that's why it's so important to make sure that companies are reviewing and analyzing the potential impact of 174 when you're structuring your intercompany IP agreements. Maybe you have special project charters if it's a big undertaking that you guys are developing. So I think that's a huge problem in the world that we live in right now, especially without further clarity. You're essentially going to lose out on a big amount of money.
Right. And, maybe a question that taxpayers are asking themselves are, how does intercompany IP ultimately impact 174? And, on our side, everyone's side, it really governs the approach on how to quantify SRE and whose Section 174 costs are they, or in the case you just mentioned, Vivian, does it need to be double capitalized? And as you said, this is spelled out in intercompany agreements, CSAs, transfer pricing documentation, and yeah, it could even be on one-off project charters for a significant multinational initiative that's impacting not just the U.S. entity, but maybe rest of world entities. And so again, depending on the documentation that exists and the facts and circumstances behind the activities and the costs that are being incurred, really that can spell out how we go through and quantify that. So in my experience, right, there has been the double capitalization situation that Vivian mentioned. It could also be that, as it's spelled out in a intercompany agreement, we had one taxpayer where the U.S. entity was solely performing services on behalf of the foreign parent. They did not have a right to exploit that research that was occurring. It was a pure reimbursement. So again, an important lens is to understand what is the reimbursement or intercompany payment mechanic that's in play. And so just based on the facts and circumstances and a detailed analysis, the answer there was actually that the costs incurred in the U.S. weren't actually Section 174 costs. They were Section 162 costs, so deductions for business expenses. Again, it's facts and circumstances really. And another situation, right, that was an odd in between was that there was a multinational company that was headquartered in the EMEA region. They had a R&D and manufacturing leg here in the U.S., and based on the transfer pricing documentation, anything done by the R&D team here in the U.S. that was owned by the global parent, there was no right to exploit that. But really, as part of what the R&D team was driving, there was local R&D coming out of that, right? That was impacting the manufacturing side. And so the final answer there was for any SRE that's being incurred by the R&D team in the U.S. that was actually, it did not impact the U.S. entity, but for the local, so manufacturing, the production side, QC, trial runs, everything on that leg actually was a 174 cost that we had to go through and quantify for the return. So again, just supplementary items to consider are going to be, what documentation is in place and, what is the reimbursement mechanic between, multiple parties.
And I feel like that adds, there's another side for tech companies that we need to make sure we're evaluating. So far we're kind of talking about intercompany IP, but there's also where you might have IP and rights to R&D when you are performing R&D on behalf of someone else. So some of the tech companies, maybe you are engaged by your customers to custom develop, XYZ software, XYZ platform, or maybe it's, developing some customizations on your existing platform, but it's tailored specifically to your clients. So in addition to evaluating intercompany IP, I think there's something that we need to consider, especially in the tech industry, where you are being paid to perform R&D under contract. So in Notice 2023-63, Section 6 specifically touches on that. And the key takeaway from that section is that the research provider is performing specified research and experimentation and retains either development rights or financial risks. Then the cost to perform specified research is 174 that your company has to capitalize. So the key here for tech companies to consider is the rights or risk stipulation. In the R&D tax credit world, you need both rights and risks in order for you to claim the R&D tax credit related to that undertaking. But in 174, you need rights or risks. So again, that adds to the broader scope of 174 costs compared to costs that you would go towards your R&D tax credit. So something to keep in mind if you're maybe performing R&D on behalf of your customers and you don't plan on exploiting the IP that's coming out of that contract, or if it's not just part of your business, it might make sense to consider putting in exclusive rights assignments to your customers. But again, it should be a business decision that makes sense and not letting 174 drive that decision alone.
Absolutely. What is the saying? The tax tail can't wag the business dog. But whenever we're talking about 174, as I mentioned earlier, this is a substantial impact, right? As a result of mandatory capitalization. So, again, another recommendation on my side is, it may not be the first thing that comes to mind, but get tax involved early, whether it's a significant ERP implementation that's impacting all entities across the company, whether it's formulating transfer pricing documentation. I've seen firsthand where the left hand doesn't know what the right hand's doing, and that some TP documentation didn't actually align with what was happening at the business. And so we are talking about impact to cash, potential impacts to financial statements. And so again, my advice would be to get tax involved with relevant stakeholders, whether it's CTO, finance, legal, and just make sure it's a coordinated effort on these elements going forward.
Absolutely agree. And on structuring a contract when you are performing R&D on behalf of others, or maybe you're paying others to perform R&D on your behalf, it's always important to make sure tax is involved and making sure that that part of the business and that part of the cash flow is being evaluated as well. Because at the end of the day, your 174 add back to your taxable income could be very substantial. Marty, any other things that taxpayers should be looking out for?
Yeah, I think so. And I think it's some stuff that both we think about as a practice and some things that have come up recently. Just to potentially oversimplify, while looking at your research credit is optional and elective, the 174 capitalization regime is mandatory. There are a number of companies early on with whom we dealt that were of the opinion or tried to take the position that, well, if I don't take an R&D credit, then I don't have to look at this 174 capitalization. That's actually quite the other way around. You really are required to look at what SRE amount exists, capitalize that, and then a side benefit would be calculating a credit to offset some of that additional taxable income hit that may happen due to capitalization. Secondly, I've dealt with a number of companies that are pretty deep in net operating losses. I've heard some of them mention like, well, I don't know why I need to focus on this too much because ultimately, even after I capitalize, I'm still not going to be in a tax-paying position. We have seen IDRs issued to clients who are deep in NOLs specific to 174 quite recently, and Vivian's been working with that client and the IRS even in discussions about how that should be analyzed. So it is on the IRS's radar. I guess as a final point, what I'll say is that in late January, the House passed the Tax Relief for American Family and Workers Act of 24, which, if it were to be passed by the Senate and signed by the president, would temporarily, shall we say, eliminate the capitalization requirement on domestic R&D back to 22, and then it would kick in again in 2026, but it doesn't eliminate the foreign capitalization requirement. It's been sitting with the Senate since late January, early February. My speculation is that it won't pass, and probably nothing will before the end, well, definitely before the presidential election coming up. So I don't want to talk too much about what may or may not pass due to the fact that I want to keep this particular podcast relevant right now. But most importantly is we're following the law as it's written. If there are new developments, we will certainly release another podcast and other writings from Cherry Bekaert. So with that said, I just want to thank Bryan and Vivian and Maggie as well for helping organize this podcast. I thank everyone for joining. And I think, as you probably heard today from both Vivian and Bryan, there's quite a bit of planning and thought that can go into the benefit, I would say, of that is attempting to minimize the amount that has to be capitalized, while at the same time potentially getting a credit that can help offset any tax liability. So thank you.